Be right back.
Don't do that.
He looks like he's just almost.
That's great. The mic is on over here. Kathy. Kathy. You said the mic is on.
I just turned it on.
Yeah, just the nose on.
It's a secret until the judge says it.
Yes,
Yes.
she said she'll speak to you.
Cool.
Private 81.
Hello.
Are you gonna give me a copy of Dorothy's affidavit now?
Yes, you can read it now, but Washington won't let you take it back to the jail. Well, we can send a copy to the jail, but you can read it now if you like.
Okay, but now you do?
What was?
Why not just
Okay.
give it to me and I'll take it now?
Yeah, you're gonna have to use the list of all the people you have to contact. You send it through the LASP with all your requests. So I have that.
Just
I have to
right.
give you a copy. It's in the DHS.
Vacancy didn't come to order, Department 81.
Seated?
You can make a group if you know how. But I don't know how to make it.
Good afternoon, everyone, and
She
Lewis,
was
why?
Chip Stevens.
I did, but I've explained all back home. I'm on a 318, so I have 30 minutes or so. Enjoy your Honor's presence.
Oh, well, you know, there's other priorities you have. But, all right.
Thank you for asking.
All right, we're back in session. Mr. Durst is here with his lawyers, Mr. Ray, Mr. Chestnut, and Bain Lewis. And for the real party interest, hit the ground running and named witnesses. We have Ms. Steinman, and you may address the court.
Yes, good afternoon, Your Honor. In defense counsel's presentation, he made no mention of the cases and the legal standard. Sanchez and Ramos, two of the leading cases, were also capital cases, and Vasco was a murder trial. All of these cases made very clear that there is a very high standard to be met when seeking materials from a journalist. The defendant has the burden to show a reasonable possibility that the specific information sought will materially assist the defense. As the appeals court said in Vasco, the defendant must show that the substance and purpose of the evidence sought will assist them materially. In all of these cases, as in the vast majority of the appeals court cases, the courts found that the defendant did not meet this very high standard, that their theory was speculative, and the evidence sought was cumulative. Here, the defense has stood before you and said there are some notes from people that hit the ground running interview. They don't identify who those interviews were of. They don't identify why they might be relevant. They don't identify what purpose they might be relevant to. All they say is that there are notes of some unknown interviews that, quote, could be exculpatory. Respectfully, Your Honor, this gets an F under the prevailing test. This is exactly what the cases say is insufficient. The identity of sources interviewed by journalists are squarely protected by the Shield Law. That's always been one of the things that is sensitive in a journalist's investigation. And here the burden has not been met. We started, Your Honor, when the defense first served a blunderbuss request for practically every piece of paper that hit the ground running, created over a 5-year period of time. You and I would have drowned in that amount of material.
I was amused when Mr. Kaufman used the term blunderbuss. Out here on the West Coast, a shotgun is a more fancy metaphor. But blunderbuss, I suppose, is...
It's very colorful.
Equally apt. You may proceed.
They seem to have abandoned that along the way, and in their papers, they rightfully, frankly, focused on the only 2 pieces of evidence from Hit the Ground Running that are centrally relevant. The interview transcripts of Mr. Durst and the March 1999 letter with the misspelling of Beverly Hills. In our papers, we established that we have turned over all of the important documents about those 2 items of evidence. We have long ago, 5 years ago, provided the complete unedited audio and video from the Durst interviews. In what I think is unprecedented, the journalists even allowed the FBI to come to the Hit the Ground Running offices and to make a forensic copy of the audio and video. The defense was provided with a copy of that. The people hired a tech expert who reviewed those tapes and determined that there was absolutely no alteration, editing, anything, that those were the original authentic tapes. Second, the defense in their papers focused on the March 1999 letter, and we established that first, we don't frankly know that much about it. It was discovered by Sareb Kaufman, who will be the principal witness about that letter, and that all we can testify to is after it was given to us and put in the safe deposit box, and our declarations describe that, and our witnesses will be happy to testify to that. So it was clear that those 2 items of evidence, which are truly what my clients can contribute to this trial, do not provide a reason to search through every email they wrote for over a 5-year period. The defense has now come in. They seem to have abandoned that, and they appeared today to say that what actually they want is the notes from some unknown, unnamed, unrecorded interviews, or at least a privilege log of that. They don't identify who these interviews were of, or why they want them, or what their significance is. As I said, Hit the Ground Running's role in this case will be rather limited. Mostly it will be to authenticate the tapes of Mr. Durst, his own words, and to provide the chain of custody information about the Sareb Kaufman finding of the letter. They will not be testifying about some unknown, unrecorded interviews. The prosecution has already provided the defense with the evidence that they will be using in this case. It doesn't include any unknown, unnamed, unrecorded interviews. The fact that the prosecution and the defense don't have something mean it's not going to be part of the case. So these unknown, unnamed interviews are just a red herring. It was also interesting and important that the defense has conceded that the Jinx is not going to be introduced into evidence in this case. The Jinx is a TV show. This is a court of law, and what will be admissible here is the unedited, complete bathroom confession and the other unedited tapes of Mr. Durst talking. His own words will be what's evidence. The Jinx is irrelevant. I obviously strongly dispute the defense's attempts to malign my clients, both the Jinx and the capturing the Freedmen. Freedmen's were fine works. They received many awards, but I'm not going to waste time doing that because it's irrelevant. Those films will not be shown to the jury. They will not be eating popcorn and binge watching them. They will be focused on the evidence. I'd like to talk about the cases because really that's what's important here. Delaney provides that we are balancing two constitutional rights here. One is, of course, the right to fair trial, which is very important, but the second is the California state constitutional right set forth in the Shield Law. Delaney teaches us how we balance those two rights and says that the defendant has the burden and must show a reasonable possibility that the information sought will materially assist the defense. Even if that threshold showing is met, the defense has to go further and show that the information sought is not especially sensitive, that the Shield Law policy wouldn't be thwarted, that they really, really need the information, and that there are no alternative sources. Here, the defense doesn't even meet the basic good cause standard for any third party, but certainly doesn't meet the requirements under the Shield Law. Sanchez, Ramos, and Vasco all show how difficult it is to meet the showing. These were all instances in which a reporter had gotten a confession from the criminal defendant. They were all cases in which the defense sought something much more narrow than at stake here. They sought either the notes for the interview, the specific interview of the criminal defendant, or the tape. Nonetheless, in all three cases, the courts found that the reporter, that the defense did not meet the standard. Each of them articulated really quite precisely why they needed the information, much more so than in this case. For example, one of the criminal defendants said, look, that this article quotes me saying that I admitted to a triple murder, but it's a paraphrase. It's not an exact quote. And I would like to see the notes or the tape, because they'll show exactly what I said. And that will be very important to my case. The court said no, that's not sufficiently, that's too speculative. Another case, the criminal defendant said, if the whole tape or notes are produced, they'll show that I was coerced into the interview, that I was misled into this interview. You'd think that would be pretty specific. The court, again, said no, too speculative. Another case, the criminal defendant said, there was undoubtedly some useful information to my defense that was left out of the article. I want to find out what else was said during the interview that would have been left out, because that will show, put the article in a different light. Again, the court rejected that, found that was too speculative. The Sanchez case is frankly the most important one. In Sanchez, the reporter had done 5 interviews with the criminal defendant. The criminal defendant had said he had committed the triple murders, that he had killed the victims for the Social Security checks. He reenacted the crime for the reporter, and he also had other instances in which he said that he was present and involved, but he wasn't the one who actually did the killing. He argued that he needed the tape of the interview because he wanted to know the actual words rather than because the reporter had only paraphrased, and he wanted to show the tapes to show that he was sort of contradicting himself, that he was inconsistent, that he was sort of confused. That he, in general, wanted the tapes because he wanted to impeach the reporter's testimony based on the printed article. The California Supreme Court said this does not meet the Delaney test. He never shows how the information sought would materially assist his defense. His argument consists of nothing more than self-serving statements, and that this is too speculative. In short, under this standard, the defense falls woefully short. These unnamed interviews will simply not be a part of the case, and so they can't be materially relevant. And there's no articulation of why or how they will materially advance the defense's case. In terms of a privilege log specifically, as defense counsel has admitted, there are no cases establishing that in a criminal case that a third party should have to produce a privilege log. As I said earlier, even listing the people that we interviewed is a significant intrusion on a journalist's independence. And there is no reason to justify such a fishing expedition here when those interviews will not be part of this trial. In sum, Your Honor, my clients have bent over backwards to Mr. Durst to produce far more material than most journalists ever produce. Before this case started, they went to the LA District Attorney's Office and they provided the complete interviews of Mr. Durst and Mr. Kaufman. It was not the television show that led to Mr. Durst's arrest. It was the evidence that they provided to the District Attorney's Office that led to the arrest. But in addition to providing those, as I said, they let the FBI come to their office. Absolutely unprecedented for journalists, but they wanted to allow both the people and Mr. Durst to be able to have 100% confidence that the tapes were authentic and hadn't been tampered with. They were then subpoenaed by the people. The people were the ones who listed the 54 interviews that they wanted produced in this case. It's very unusual for journalists to do that, but they turned them all over, again, in an attempt to be fair. The defense issued their broad subpoena. We produced 1,800 pages in response to that, consisting of all of the communications between Hit the Ground Running and the LADA's office prior to the arrest. So at extraordinary expense and frankly time, they have produced a substantial amount of material, but enough is enough, Your Honor. And the information sought at this point is just a fishing expedition, whether you call it a shotgun or a blunderbuss or whatever metaphor you use, they have not met the standard, and it's just guesswork. Thank you, Your Honor. Do you have any questions?
Not substantive. I'm just now trying to think of a better metaphor than fishing expedition. We have these sporting...
Trolling.
Trolling. Okay, there you go.
I realized at one point I was thinking about an ocean of documents.
You're not supposed to help them, Chip.
I read your moving papers quite carefully, so thank you. I have no questions.
No, thank you very much, Your Honor.
All right. The threshold issue, before we get to the threshold issue, the evidentiary issue is judicial notice. So as far as judicial notice, the facts sought to be proved must be relevant before I take judicial notice of evidence. And so here we have a request by the defense to judicially notice various news articles and other documents. And they largely consist of criticism of the editing and other aspects of the Jinx, which are not relevant because they're not evidence against Mr. Durst. Indeed, the original evidence is what is admissible. I'll point also that Mr. Jarecki is not on trial. It is Mr. Durst who is on trial here. The judicially noticed material, if it is relevant, may prove the fact of a publication, if that matters, but not the truth of the published facts. So the court will decline to take judicial notice of the publications. If the publication itself is relevant, the court will consider that for such limited purpose, but that's not been shown. Now as to the nature of the immunity here that we're discussing. And despite the defense criticism of hit the ground running, no one can reasonably question that they do meet the very broad definition of journalists. Even if the defense claims they're bad journalists, still journalists they are, and they're protected by the First Amendment and statutory immunities. So they may be compelled to give up their unpublished work only to protect the right to a fair trial. And that doesn't mean if there is a trial, they give it up. Under Delaney, there still must be a plausible basis for discovery, and then the court balance the interests. Mr. Lewis asked me in a very, or described a vividly described a scenario wherein the trial would be interrupted by some unpublished material coming to light, which might raise reasonable doubt of guilt. I'd have to give a continuance for investigation of that. But of course, one can always fantasize such a situation or reason that anything is possible, and because anything is possible, there ought to be discovery of the possibility. But it's hardly a basis to compel a journalist to give up protected materials. So as far as the idea that some material might come to light which might fundamentally change the nature of the trial or affect the accusations, well, what reason do I have to believe this is so? And there's none given, just the imaginative description of a scenario. And then the question is put, I think, from the common sense perspective of a very, very bright 12-year-old, how can we know what they have if they don't show us, if they won't let us look at it? The obvious answer, I suppose, is, well, then follow the defense request to let the court look at it. But it doesn't quite work that way, of course. The people have turned over what they have, and that is voluminous. Mr. Durst knows what he did and did not do, and if he needs access to something specific to help him prove it, this court is here to protect those rights. Can the defense just say, give me everything in the world that a private person has so I can find something that might help me? No. It must be specific. But wait a minute. The defense is not talking about just any private person, rather the people who investigated Mr. Durst privately and then called the police. And was he indeed prosecuted because of the Jinx? Well, in a sense, but actually he is arrested and charged because of the evidence that is provided. So it's due to the evidence, not due to the accusation. The accusation is not what is at issue, it is the evidence. But in People versus Serrata, where a private company investigated a crime at that company, that's 62 Calat 3rd, page 9, so notwithstanding the fact that a private investigation did lead to the arrest of Serrata, a burdensome subpoena still was quashed on account of its quote-unquote blanket nature. Again, an odd metaphor, but it is a blanket request, a broad request for every conceivable document that might bear upon the case. And Serrata, after describing the blanket, moved to yet another metaphor and said this blanket is but a fishing expedition. I would not mix those metaphors, but still, a fishing expedition is the characterization of a discovery request that is so complete and comprehensive as to ask this company to turn over all of its material. It's too broad and burdensome. Now, that's all right. I want to be specific about the request. I want to focus on the very specific requests and not make a blanket ruling about a blanket request. let's talk about these 3 taped interviews. So I haven't been given any reason to believe they're of any consequence. I mean, certainly if they were incriminating, they would be used. The suggestion here is they are not incriminating and hence they were discarded, or perhaps they were exonerated. But again, this is entirely speculative. We don't know what they are. So let's return to specificity. If there is something that Mr. Durst needs to prove and he can't get access to witnesses or documents that support that point, specify and you shall receive. But part of the journalist's immunity is that I can't and should not make them simply open their files. There's a fact you need to prove that can be proved exclusively in that way. And if I didn't turn that over, that would not be a fair trial. But to broaden the conception of a fair trial to the idea that a confession can be such a damning evidence, it's maybe hard to overcome. I've been given authority to that effect. Yet, there's nothing that is specified that would tend to directly undermine that. There's the question of the authenticity of it. We'll talk about the authenticity of it. And second, the bias of the filmmakers. We'll talk a little bit about bias. That's the closest the defense comes to justifying the request. I recognize there is a theme to the defense. There's a media frenzy villainizing Mr. Durst and driving a rush to judgment. But again, a theme is not a defense. Now, the filmmaker's process, as you described it with editing and creation of dramatic effects, may affect the so-called court of public opinion, but it's not material to the evidence actually presented in the case. Again, the idea that this film would be made that is so critical of Mr. Durst may suggest that the filmmakers are biased. So what if the filmmakers hold a bias or grudge against Mr. Durst? And of course, the jury would be so instructed. Any witness could be evaluated for that and should be evaluated for that purpose. As I understand it, the testimony of these filmmakers is simply as to their they authenticating these documents. Now, filmmakers do appear in the interviews, but of course their questions are not evidence. They're evidence in a sense, but much more like a questioner's question is not evidence. The answers are what is evidence. The questions are not significant. So whether the person is biased in asking a question, it doesn't really matter too much. It's the answer that. Asking a biased question doesn't matter. It's the answer that matters. So, is the bias such that there is reason to doubt the authenticity of the confession and of the comparable handwriting? First point here is that discovery, as I understand it, appears complete here. I don't think there's anything specific that is missing here. I guess there aren't emails or letters describing what is actually filmed as far as turning over the handwriting, and that's what I understood. So none of the requests is specific as to the authentication or chain of custody. There's no reason to believe it's inauthentic. There's no showing that there's any reason to believe there's tampering. There's no suggestion of such. And it's not necessary for the real party in interest to demonstrate this, but they've affirmatively documented a report from an independent lab to show that there isn't that tampering of the audio. Do you need to leave?
I do, Your Honor, but I didn't want to interrupt you.
I'll excuse you. I'll get you a transcript of this. I'm sorry that we've been delayed, and I'd like you to.
It wasn't the court's fault. Thank you very much, Your Honor. I look forward to seeing you soon.
All right. Thank you, Mr. Lewis. Good luck in that. What's the team called? Go team.
Bears, Spring Branch Bears.
Go Bears. I'm already comfortable saying that, right? So,
With
I
Chip
think
as the
they're better
coach.
than you're on.
Chip is
they're probably better than my Bears. My Golden Bears.
They'd have to be.
Yeah.
With Chip as the coach, Your Honor, they're the bad news bears.
I don't want to go out on a limb here, but I mean, there's no claim by the defendant that these are false. So I just mean to mention this because it's the same as the Fourth Amendment. In other words, in that a person can make a claim, they're not waiving any rights about self-incrimination to make a claim that I was there and it didn't happen that way. In other words, a claim can be made and it's not admissible in the trial to prove his guilt. So that's Simmons versus U.S. 390 U.S. 377, right? So there's nothing from him saying that this is wrong, if this didn't happen this way. And Evidence Code 412 says if it's within the power of a party to produce better evidence, and they do not, it's presumed that it's something that can be taken as a concession, really. But even without 412, even without using that idea, there's nothing here and only the other, only evidence showing that this is authentic. The creation, this recording of the statements and of the receipt of these comparable documents with comparable handwriting. So I don't see anything there. I also have to look about whether discovery is cumulative as to 54 complete witness interviews and all of Mr. Durst's interviews. That seems like a very comprehensive discovery and much material. And there's a question about whether there's an alternative source of material for cross-examination or to prove a case. Certainly the 54 transcripts apply, and whether an alternative source requirement applies depends on the facts of each case. That's Delaney. Yes, that's Delaney. And here, I think in this case, the court may require consideration of the alternate source. In People versus Sapp, the defendant himself can be the alternate source, the alternative source. And People versus Sapp, Calat 4th 240 at page 273. Which means, and I don't think there's anything wrong with that. Sometimes there are burdens placed on a defendant to prove something. Self-defense. How do you know there's self-defense? Well, how do you raise the issue of self-defense? Sometimes a person testifies. And I just don't see the Fifth Amendment problem that is suggested here by the defense. I think he's an alternative source, but 54 witnesses, I think that's sufficient. I wanted to look at the specifics. So the first request is any and all documents related to the HTGR parties interacting or meeting with law enforcement, et cetera, et cetera, et cetera. And the thrust here seems to be discovery to support the agency argument, which is not pending, and the materiality, I think, is, well, it's absent. Again, this whole idea of the bias of filmmakers for turning over the material to law enforcement, the idea that they're biased is not pertinent. And also, there was, I know the defense cited some authority. Very interesting. It was in, it was a Brady case that talked about whether or not suggested that that information about an investigation was Brady material. It was interesting. It was, I believe, it was dictum in that case, because if it's discoverable under Brady, that doesn't necessarily mean it's admissible here or relevant in this case. Well, in any event, I think it's not material, this first idea here of cooperation. And then there's the alternative source, that is, to the extent that the communication went to law enforcement then is revealing it to the defense, their side of the communication. There's no reason to believe they have not. I have been told that they have not. Second item, any and all statements and recording of all persons interviewed, questioned, or identified or presented in the Jinx, but not limited to all correspondence, all notes, recordings, calendars, lists, or similar items or documents. So that's the closest we've come. As I see it here, it's the closest case, so let me pause that one. The third question, any and all documents, communications, photographs, notes, or similar items or documents provided to hit the ground running by all persons interviewed. All documents, communications provided by persons interviewed. The idea there, the only possible idea here that would work would be that there's something inconsistent. There's some inconsistent statement here, and I'll address that. For all raw footage from the Jinx, development, research, interviewing, meetings, negotiating, filming, editing, sale, and distribution of the Jinx, clearly overbroad, and to some extent it overlaps number 2, which I'm going back to. 5, the unedited camera master files from the Jinx, that's immaterial. 6, all documents and materials that show all edits, time jumps, or similar processes from the Jinx, again, immaterial. Not only is there no showing that the meaning of the statements was changed by their order, but it's not even coming into the courtroom. We're only going with the unedited material here. That's all I'll allow in. 7, all production notes for the Jinx, immaterial for the same reason. 8, all documents reflect the sale, distribution, assignment, or licensing of the Jinx on any platform. That's not material. 9, all documents reflect all public appearances, including TV appearances, interviews, seminars, public speaking by Jarecki, Smerling, Pontier, or anyone else on behalf of the HTGR parties regarding Robert Durst or the Jinx after March 14th. So obviously there's an alternative source because they're public appearances, but it's immaterial and overbroad. So let me go back to statements and recording of persons interviewed beyond the 54. And it's really going to be, because you have the 54, they're all turned over. and any and all documents provided by persons interviewed. As to these, I think Sanchez applies. 12 Cal 4th at 1, page 1. The defendant never shows how the information sought would materially assist his defense or how it differs in content from the testimony and published information available for cross-examination. I think this is kind of comparable to People versus Vasco, 131 Cal 4th, 137 and 155. It doesn't meet the threshold. It's not significantly different from what we have. Thus, as to the entire subpoena, there's no reasonable possibility that the informational material assists the defense. The motion to compel is denied. The motion to quash is granted in full. All right, let's take a break, and then I will return for the handwriting, the Sargon hearing on handwriting.
Your Honor, you just had the Sargon hearing. It's not my understanding that we're having an actual Sargon.
Well, it's not an evidentiary hearing, but I am going to hear now, based on the documents that are provided to me, whether I will allow these witnesses to testify to identification. And I'm going to rule on your request to present a witness at trial. And everything that was briefed. We're not calling witnesses today.
Okay.
All right?
There's no one, Your Honor, I don't know whether the court wants to take care of this before the break or after. There's a witness that is in court
Yes?
that I'm concerned. I want to get this witness ordered back.
Who's the witness?
Yes, so, and because it's Doug Oliver.
Yes, Mr. Oliver is present.
O-L-I-V-E-R. Mr. Oliver is in the courtroom.
Yes.
He has been very uncooperative in any conversations we've had with him.
Yes.
Because he's in New York and has told us in the past that we'll have to find him in England, etc. We would like for the court to order him, either he can be in court on February 11th.
Well, no, we're gonna be here. I mean, we talked about a later start, but shouldn't we have an earlier date, or do you want to pick a February date?
Well, Your Honor, this is what I would like if the court's willing to do it. I don't want to inconvenience
Yeah, I'll
the
order
witness.
that.
This is what I was going to say. If the court will agree that the witness is to be on call to us with we will notify him 3 days in advance when he needs to be out here, then he can be on call. That's doing a favor to the witness. If not, then we're going to order him to come back here every time we're in court. It doesn't
Right.
matter to me.
Right.
Whatever the court wants to do.
Sure, I don't want to inconvenience a witness. On the other hand, he's been described as a witness both for the people and for the defense, so he's obviously important. I don't mean to inconvenience him, but he has to be here because for the aforementioned fair trial.
Can the court make that order, Your Honor? He's in court right now. Can the court then order him either to return on whatever date the court is going to say, or to order him to be on call with a number to us, given the what I've described? So in other words, Your Honor, if you don't order him, we don't have jurisdiction
No,
over
I'll
him.
do it.
Thank you, Your Honor.
So Mr. Oliver, Mr. Oliver is in the first row. And what other information do I need? Doug Oliver? Okay, and Mr. Oliver, the District Attorney, Deputy District Attorney, Mr. Lewin, has asked that I order you to return to this court, that you be on call, that I not make you come back every time we're in session, but rather to agree, and I will order you, but if it's better, I think this is better for you. So I will order you to be on call to Deputy District Attorney John Lewin, that you return to this court within 72 hours of him giving you notice that you are to be here to testify as a witness in this case. Mr. Oliver, any questions?
Well, I'm in New York. I think 72 hours. Yeah, I do have.
Very well.
I think a reasonable time would be a lot more time. I mean, I don't know. I don't quite understand how this works, but
A week is fine. Can you also have him give a phone number, Your Honor, that he will respond to? That's been an issue in the past. Well, we can give him 7 days, Your Honor.
How about this? 7 days, people are nervous about being able to get here on time, so they're talking about 72 hours. If we can get a phone number that's a valid phone number for you, we can make it 7 days. will you tell Mr. Lewin or one of your detectives to their satisfaction what that number is? Or you don't want it on the record, do you, Mr. Lewin?
No. Your Honor, finally,
Do you get the number? I'm asking you to get the number, and then I'm going to make it 7 days, but let's...
Okay. Yes, you're asking me to walk over and get the number from him? I'm sorry.
Detective Shannon will get the number.
The detective Salem, okay.
Your Honor, the final issue on this...
Let me make the order. You agree to give the phone number?
Certainly, I'll give you further, but 7 days is, I travel a great deal, and I really need much more time because it so happens that I know in the month of February I need to be in Singapore, but I don't know the exact date, so.
He'll work with you, but I'm giving you 7 days.
Your Honor, and the last thing, could you advise also the witness, he has requested before that the only way he will come out here, quote, he will not fly commercial, we need to pay for the fuel for his private plane. We have informed him that the county does not do that. Can you please let the witness know that he's going to have to fly out here, coach like any other witness, and that we will not be paying for gas for his private plane or flying him in a different style.
But you will pay airfare.
We'll pay airfare, he'll get a coach seat like
Mr.
everyone else.
Chesnoff.
No, I just want to move things along, Your Honor, because unlike other people, I have other things to do.
No, we all have things to do.
Yeah, I understand.
It's important.
So here's the other thing, Your
Mr.
Honor, I don't think the record should be that he has not been cooperative. I don't know the interaction, but not wanting to talk to a DA is a right of an American, so I would characterize that as uncooperative.
Okay, well, whatever it is, I'm ordering you, sir. I'm giving you seven days. We got some reason. These are not actually unreasonable people. You'll find out. So 7, but they're firm, all right?
Yes, Your
So
Honor.
7 days from contacting. You'll give your number to the detective, and I order you to return to this courtroom with 7 days' notice from Mr. Lewin or his team at the LA County DA's office.
Thank you, Your Honor.
Yes. Now, I wanted to get my materials because I couldn't carry all the handwriting and the quash in one trip. So how many minutes you want to take at your break? 10 minutes? 15? Huh? 10? It's early, but we'll break early.
Your Honor,
He doesn't want to give it to me.
I really,
he's not giving
gentleman
Detective
has his number.
Shanley.
I really don't want to give my number. I don't trust him. I'll give it to you, sir.
I'm not calling. I don't call witnesses. Yeah. How about this? How about I
I've been
make
doing
it
it
72
several
hours?
times with this gentleman. I really don't want to be called. How about if you give it to one of these gentlemen here?
Pointing to the defense attorney?
Yeah.
this is how it's been, Your Honor.
Yeah, I get it. If you want 72 hours, it's okay to put it on the defense.
No, we want his phone number from him
Okay.
as the court ordered.
That was actually voluntary. I don't know if I can compel phone numbers. I can compel a tenant.
Just whatever.
Yeah,
Give me some
you
authority
know what,
for
Your Honor,
compelling phone
let's make it easy. Just order him to be back in court on the next court date. We'll have him come back here every single court date. If that's the way he wants to do it, we've tried very hard.
No, I
He doesn't
think-
respect
okay.
anybody's authority.
Listen, right. I mean, right. If you order him back, if he doesn't show up, then I put out a warrant. It's easy.
Your Honor, could I just inquire,
Yeah.
because I understand from what he was just saying to the detective that Mr. Lewin already has his phone number.
Well, the problem is I continue to call, he doesn't return phone calls, and I know what's going to happen because it's happened already. He'll make an arrangement to make a call, he'll then say, I was on a plane, I couldn't call you, I'm in England, don't bother me.
Well, on call doesn't sound very good then, does it?
Your Honor, I'm trying to work with the man as best I can, it hasn't been easy.
Your Honor, I think that the court's order says he has to appear within 7 days of receiving a phone call. If they have his phone number, tell him to call his number, leave a message, document it. If he doesn't show up
How
within
about
7
this?
days.
How about I order him to come back and you can make arrangements if you're satisfied with him to come back on call?
Huh?
That's good.
I'll put him, yeah, good?
Yeah, perfect.
Okay, I want to keep that date, the January 13 date.
Perfect.
So I'm going to order you to return Mr. Oliver to this courtroom on January the 13th, 8:30 a.m.
Thank you, Your Honor,
Yeah.
and maybe
20, January 13th.
13, depending on the court's time how the court wants to do it, there's an issue regarding how we will end up handling Mr. Drecke, Mr. Smerling, Mr. Pontier's testimony. Because their attorneys are here today, I was hoping that we could briefly, with all the attorneys, speak in the back, either depending on the court schedule and their schedule, before we do this handwriting motion, or after, so that we take advantage of the fact that the lawyers are here, because there are some issues that I think would be helpful to get out today while everyone is available.
Okay, who's catching a jet? Raise your hand.
I volunteer.
Not the audience, but thank you. I'm on council.
Your Honor, when court is over today, I am going to visit a person in a lockdown psychiatric facility where I may choose to stay.
Yeah, me too.
But I really don't have time today to accommodate.
For that part?
Yes.
Because I've never heard of that.
We'll try anyway. We'll see how expeditious it is.
Thanks, Your Honor.
We'll do the handwriting in a minute. Okay?
Thank you.
Because when is it?
10 minutes.
Handwriting, and then, you guys have to know that.
You'll just have to drive.
Where do you need to go? You need to go someplace more than that?